Hello friends, welcome to our channel Random Dictation. Subscribe our channel for more dictations on regular basis. Get ready. As regards the breach of 50% ceiling of reservations, the contention is that the said ceiling is not inflexible or inviolable, and in the context of the object sought to be achieved, 10% has been provided as the maximum by way of the enabling provision. Stop. With the foregoing outline, we may usefully take note of the reference made to the Constitution bench for determination of the substantial questions of interpretation of the Constitution as are involved in these matters, and the questions formulated while commencing the hearing. Stop. By an order, a three-judge bench of this court took note of the issues arising in these matters and referred the same for determination by a constitution bench while observing inter alia as under stop para. By virtue of the impugned amendments, very constitution is amended by inserting new clauses in articles 15 and 16 thereof, which empower the state to make reservations by way of affirmative action to the extent of 10% to economically weaker sections. Stop. It is the case of the petitioners that the very amendments run contrary to the constitutional scheme, and no segment of available seats or posts can be reserved only on the basis of economic criterion. Stop. As such, we are of the view that such questions do constitute substantial questions of law to be considered by a bench of 5 judges. Stop. It is clear from the language of Article 145 within bracket 3 of the Constitution and Rule 1 within bracket 1 of the Supreme Court Rules 2013, the matters which involve substantial questions of law as to interpretation of constitutional provisions, they are required to be heard a bench of 5 judges. Stop. Whether the impugned amendment act violates basic structure of the constitution by applying the tests of width and identity with reference to equality provisions of the constitution is a matter which constitutes substantial question of law within the meaning of the provisions as referred above. Stop. Further, on the plea of ceiling of 50% for affirmative action, it is the case of the respondent Union of India that though ordinarily 50% is the rule, but same will not prevent to amend the constitution itself in view of the existing special circumstances to uplift the members of the society belonging to economically weaker sections. Stop. Even such questions also constitute as substantial questions of law to be examined by a bench of 5 judges. Stop. Pursuant to the order aforesaid, this batch of matters has been referred to this constitution bench for determination of the issues arising from the challenge to the 103rd amendment. Stop. The court is after perusing the issues suggested by learned counsel. Stop.